Welcome to the case debrief of Alice Bennett v. Richards Haley. I'm Final Matteo, and I'll be presenting the high points and steps of the case to you. This is the final assignment for Accounting 536. Throughout the case, you will learn who Alice Bennett is, why the case was pursued, the steps taken during the case, key witnesses, and the edge judgment. At the conclusion of the presentation, if you have any questions, please feel free to contact me with any questions. The parties and their attorneys of the case involve the plaintiff, defendant, witnesses, attorney for the plaintiff, and the attorney for the defendant. Alice Bennett, the plaintiff of the case, was represented by Anthony Righetti, an attorney from Righetti, Morgan, and Blake. Righetti, Morgan, and Blake is an attorney office located in Greenville, New York. Richards Haley, the defendant of the case, was represented by Vanessa Graves, an attorney from Miller, Graves, and Klein. Miller, Graves & Klein is an attorney office located close to the office of Richards Haley in New York, New York. Lastly, the witnesses included Darren Blackwood, Martina Yardley, and Ray Bradley. The witnesses are all employees at Richards Haley who played a part in hiring or being hired for the training and development manager. After reviewing the requirements of employee discrimination lawsuits, it was decided that the discrimination lawsuit should be filed with the United States District Court, Southern District of New York. Title VII, an anti-discrimination law, is governed by the federal government. Therefore, the federal government would have subject and personal matter jurisdiction over the state of New York. Additionally, the federal court has the capacity to hear the claim for infliction of emotional distress that was inflicted on the client due to her experience with the defendant. Evidence and documentation are crucial pieces of proving a case to be true. In the Bennett case, it was beneficial to our team to collect forms of evidence such as testimonies, documents, demonstrative forms, presumptions, judicial notice, and electronically stored information, also known as ESI. The evidence could be based on emails, memos, security cameras with vocal recording, or complaints filed to managers or human resources. Personally, we asked Ms. Bennett to provide as much documentation as possible. Although it may be difficult, the plaintiff shall provide documentation of the continuous criticism and comments made by Martina Yardley. A stipulation enlarging time to respond is an agreement between the attorney and an action by which the defendant's attorney has additional time to respond. After filing Alice Bennett's complaint, the defendant's attorney requested additional time to respond. Therefore, the plaintiff's attorney agreed to extend the response by 20 days of the initial deadline. After interviewing several witnesses and reviewing various documents, the firm decided that Alice Bennett's case included cause of action for breach of contract that existed. Unfortunately, due to the defendant refusing the altering of the complaint, our law office thought it was in the best interest of the plaintiff to file a motion to amend the complaint to ensure we can include this additional complaint and topic in the lawsuit file. The closing argument of the motion to amend the complaint was based on the facts provided to the court that the plaintiff claims good cause for amending the original complaint. The motion to amend the complaint is based on factual evidence that was correspondent with the case in its entirety. Theron Blackwood, a manager of Richards Haley and the supervisor of Alice Bennett, claimed that management liked Miss Bennett's work, but that her image didn't fit the role. Blackwood, in an interview with paralegal Thomas Perth, said that his impression of Alice was that she seemed very competent, had good academic credentials, and had experience in training employees. Furthermore, the evidence of emails continued to suggest the involvement and witness of claims from Martina Yardley and Reese Bradley. All three persons were key players in this case. On October 7, 2019, Martha Yee, a former employee of Richards Haley, took an oral deposition before a notary to answer questions pursuant to Rule 30 of the Federal Rules of Civil Procedure. The deposition was held at the plaintiff's attorney's office located at Rigetti, Morgan, and Blake on 34 Court Ave, Greenville, New York. In compliance with the laws in respect to the defendant, the attorney of the defendant was notified of the deposition. In accordance with the defendant receiving a notice of deposition, Martha Yee, a previous employee of Richards Haley, was served a subpoena duce tectum. A subpoena commanded Miss Yee to provide testimony and surrender evidence in relation to the Alice Bennett v. Richards Haley case. At the meeting, Miss Yee was to provide any documents, records, or other tangible things which were in her possession, accessible to obtain, or under her control. Any items that were handed over were to pertain to employee discrimination and sexual harassment at Richards Haley. Interrogatories are written questions submitted by one party in a lawsuit to another party in that suit. In this case, the plaintiff requested that the defendant answer 5 written questions that corresponded to the case. Richards Haley, defendant, was given 30 days to respond to the interrogatory. Questions such as who worked under Miss Bennett, or any workers reluctant to work under the plaintiff, describing the hiring process, what documents pertain to the hiring process, and an explanation of the documents were directed towards the defendant to answer. In accordance to the complaint of physical and mental suffering, the attorney of the defendant requested that Alice Bennett have both a physical and mental examination conducted. Ms. Bennett's attorney agreed to a mental examination. However, the request for a physical exam was denied. The examination was scheduled for October 25, 2019, and would be conducted by Dr. Peter Ebert, a board-certified psychiatrist. Prior to the exam, it was suggested that Ms. Bennett review the medical recap sheet that she previously prepared so that she could promptly respond to the doctor's questions. Pursuant to Rule 34 of the Federal Rules of Civil Procedure, Alice Bennett, plaintiff, requested for production of documents from Richard Haley, defendant. The request for production of documents was to be completed within 30 days or within an agreed timeframe confirmed and signed off by both parties. The requested documents included any written, rewritten, modified, sent, or received documents between the date range of April 1, 2019 to September 30, 2019. The request for documents included any definitions surrounding what forms of documents was included from the phrases computer and document. Each of the documents provided by the defendant were requested to be in original format unless otherwise agreed upon. If any attributes or questions arose, the defendant was requested to reach out to the plaintiff's attorney. Ms. Bennett was served with a set of requests for admissions. The defendant addressed 5 different questions. The plaintiff's attorney was caught off guard by the information that was being questioned. However, Ms. Bennett was honest in her responses and acknowledged that the information being questioned should have been shared regardless of how she felt that the information was irrelevant to the case. The responses were answered and timely filed. After all discovery techniques were exercised on both sides, the plaintiff took action in proposing a settlement agreement. The agreement had been made and entered into on October 4, 2019 in New York, New York. The settlement was proposed for the sum of $1 million and full satisfaction of the claim made against the defendant. If accepted, the defendant agreed to pay the plaintiff $1 million in the arrangement of $150,000 payable in cash at the time of the signed and final settlement agreement and $850,000 payable over a period of 6 years. Therefore, the plaintiff were to receive $11,805.56 on the first day of each month for the next 6 years. The defendant received the settlement agreement but declined the agreement that was created. The trial was taken to court, but unfortunately, it was ruled that Alice Bennett didn't have the evidence to prove that employee discrimination occurred. In response to the trial ruling, the attorney of Alice Bennett decided to move forward in filing a notice of appeal and request for reporters' transcripts. Throughout the trial, we have learned more about the plaintiff, why the case was pursued, the steps of a civil lawsuit, and the methods of discovery. Although the results of the Alice Bennett v. Richard Haley case weren't the outcome that Ms. Bennett or Ragetti Morgan and Blake's law firm was hoping for, the plaintiff could have had a second chance to win the trial. If the notice of appeal is approved by the court, Ms. Bennett may have a chance for a retrial. Thanks for tuning in to the Alice Bennett v. Richard Haley book case recap.